One other thing, we had said we were going to let that alternate juror go because, since they're all here, do you have any objection to me letting Mr. Weissman go? He's got that plane ticket Saturday morning. So I'll state that for the record and we'll allow him to leave.
Okay.
All right.
Common Pleas is now in session. The Honorable Allison McCarty presiding.
Thank you. Be seated. All right, before we get started here, one of our jurors, one of our alternates, indicated early on that he had some non-refundable plane tickets to somewhere good. I can't remember where.
Las Vegas area.
Las Vegas area, okay. And those are Saturday morning? Yes. And so the court had indicated to you when we talked the other day that assuming everybody showed up here today and we had everyone still ready to go, that the court and the parties discussed it and that we would be willing to release you with our thanks for all of your hard work on this case and patience and flexibility. So I did check with the parties, but just for the record, does the state or does the defense have any objection to releasing Mr. Weissman, our alternate number 3?
3. No objection. None from the defense, Your Honor.
All right. So, Mr. Weissman, I am going to tell you, however, you still remain under the admonitions about discussing the case. You are free now to, as I'm releasing you, you're free to view the media, you're free to go back to your normal, I guess, way of obtaining news, but you're just not able, I'm asking you not to discuss the case until the case has been finally concluded and the court will, basically Shay will call and probably leave a message on your cell phone or on your home phone indicating that you're released from the rest of the admonitions about discussing the case. You understand?
Yes, thank you.
All right, thank you so much. And I just ask you to go ahead and you can be excused and turn over your notepad and everything to Shay. And thank you so much.
Thank you.
And you want to play a little musical chairs there? And there you go. All right. Thank you. All right. Members of the jury, during the trial phase of this case, you heard evidence, testimony, and arguments of counsel and found Kenan Ivery, the defendant, guilty of numerous charges and specifications. In this sentencing phase, one of those specifications will be addressed and called an aggravating circumstance. You also heard during the trial phase some evidence, testimony, and arguments of counsel as to possible factors in mitigation of the death sentence. In this sentencing phase, which concerns only the determination of sentence, you will hear additional evidence, testimony, arguments of counsel, and perhaps a statement of the defendant. It is not necessary that the defendant take the witness stand or make a statement. The defendant has a constitutional right not to testify or make a statement. The fact that the defendant chooses not to or does not testify or make a statement must not be considered for any purpose. The state will address the aggravating circumstance of which the defendant was found guilty, and the defense will address mitigating factors. In this case, the aggravating circumstance is precisely that set out in your verdict on Specification 1 to Count 1 of the indictment. It is as follows. Having found the defendant guilty, we, the jury, further find that this offense of aggravated murder was part of a course of conduct involving the purposeful killing of or attempt to kill 2 or more persons by the defendant. This aggravating circumstance was proven in the trial phase, and it is not necessary for the state of Ohio to present further evidence to you regarding this aggravating circumstance. However, only this aggravating circumstance may be considered by you during this sentencing proceeding. The aggravated murder itself is not an aggravated for the following 4 sentencing options for your consideration. Life imprisonment without parole eligibility for 25 full years, or life imprisonment without parole eligibility for 30 full years, or life imprisonment without the possibility of parole or death. You are here today to consider which of these sentences to impose. The aggravating circumstance will be weighed against the mitigating factors that have been or will be presented. Mitigating factors are factors about an individual or an offense that weigh in favor of a decision that a life sentence rather than a death sentence is appropriate. In order for you to decide that the sentence of death shall be imposed upon Kenan Ivery, The state of Ohio must prove beyond a reasonable doubt that the aggravating circumstance of which the defendant was found guilty is sufficient to outweigh the factors in mitigation of imposing the death sentence. The defendant does not have any burden of proof. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced that the aggravating circumstance of which the defendant was found guilty outweighs the mitigating factors. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. I remind you not to discuss this case among yourselves or with anyone else, not to permit anyone to discuss this case with you or in your presence, not to discuss the case with anyone present in the courtroom or associated with the parties, and not to form or express any opinion on the case until it is finally submitted to you. I also remind you not to watch, read, listen to, or discuss news media accounts of this case. Please follow all of the admonitions I previously gave to you in writing. The order of the trial in the sentencing phase is as follows: opening statements of counsel, the state's evidence, if any, the defendant's evidence, if any, the state's rebuttal evidence, if any, the defendant's statement, if any, the final arguments of counsel, the final instructions of law from the court, and your deliberations. Again, you will be deciding that the state of Ohio has proved beyond a reasonable doubt that the aggravating circumstance outweighs the mitigating factors. You will find, if you find the aggravating circumstance outweighs the mitigating factors, then you must find that the death sentence be imposed upon Kenan Ivery. However, if you find that the state of Ohio did not prove beyond a reasonable doubt that the aggravating circumstance outweighs the mitigating factors, then you will enter a verdict imposing one of the life sentences: life imprisonment without parole eligibility for 25 full years, life imprisonment without parole eligibility for 30 full years, or life imprisonment without the possibility of parole, whichever you deem appropriate. You will again be sequestered during your deliberations. And now we will hear the opening statement of counsel. Ms. Shuki?
So we have now reached this phase of the trial, from our second trial here, which we discussed with you in your 1 year, many weeks ago now, that you may at some point, if you found the defendant guilty of aggravated murder with the specification, that we would then be coming back to this sentencing phase. And now it's the time to determine what sentence, what penalty is appropriate for the defendant in this case. Now, the judge gave you some instructions. I'm going to go over them a little bit for you. It's just to add, we know this is not a pleasant experience. We know this is a very, very difficult decision for all of you. And we appreciate that. You have a hard job ahead of you. You've taken an oath to follow the law, and we know that you will do that. And we have confidence in your ability to follow the law. And whatever you decide as a jury as the appropriate sentence, we respect that. The verdict in this case, your verdict, agreeing with the state that the defendant committed aggravated murder, and that during the course of conduct of committing that aggravated murder, he did kill or attempt to kill 2 other people, and also killed Justin Winebrenner. Those 2 other people being Dave Eisel and Dave O'Kane. That he purposely did attempt to kill those 2 men during that course of conduct of the aggravated murder of Justin Winebrenner. Then the aggravating factor that we proved to you in the case last week, you already found it, you already heard that evidence, and you already made that decision, that was an aggravating factor. So at this point, we move on to a different phase where the defense is actually going to provide evidence. So in this particular part of the trial, the state is not going to call witnesses like we did before. We're not going to be putting on people to talk to you. They're not going to give evidence. We are, frankly, going to go ahead and do some exhibits, things you've already seen things that you've already considered in the first trial case. And we're going to do that again. We're going to mark certain things and say, here you go. These are important to your decision determining the aggravating factor in this case. So we'll do that. We're not going to be calling evidence, evidence. Because we'll do that. We will give you some evidence, exhibits, and we will rest. Okay? But we're asking you to remember and think back on all the evidence, take into consideration all the evidence that we put forward in the trial phase that goes to the aggravating factor in this case. You're asked to allow to do that. At the close of then the presentation of the defense's witnesses, okay, we will come back here and stand up again and argue to you why we believe the aggravating factor in this case outweighs any mitigating information that the defense is going to give you. Okay? And we talked about that in the year a little bit, the legal standard in Ohio. Okay? We did a lot of discussion about that, and perhaps you remember it. The judge now re-instructed on it. But that's what we're going to be doing. The legal standard, following the law in this case, as you know what to do, is to weigh that aggravating factor, okay? That killing of Justin Winebrenner, aggravated murder, purposeful, prior application and crime, that plus the aggravating factor of purposely attempting to kill two or more people, and that aggravating factor outweighs any mitigating evidence that the defense is going to give you. That is the law, and if you find that that aggravating factor, which the state provides to you and the state argues to, is enormous, the aggravating factor, we believe, is immeasurable in this case. If you find that the aggravating factor outweighs that mitigating evidence, then you must find the penalty of death. As the judge has said many times reviewing an individual voir dire, if you find that aggravating factors outweigh any mitigating information, then you must sign the verdict for death. Not would, not should, not may. So in this case, you can decide what weight to give to the mitigating information that the defense is going to provide to you. You decide individually the quality, basically, of that evidence in your weighing process. You'll be listening to their witnesses and making those determinations. You can decide based on your individual weighing, okay, of the mitigating evidence. But one thing you can't take into consideration is empathy or sympathy for the victim and the victim's family, frankly, or the defendant and his family. This is an objective standard that the judge has indicated to you. So something like sympathy or empathy for either party is not appropriate under the law. We asked and we talked about in what you're doing in the past that we have to put aside those things when you're listening to the facts and listening to evidence. And we're asking you to do that again. Put aside empathy, sympathy, okay, and look at the case objectively when you're weighing those mitigating factors. So, in the end, we understand the seriousness of your decision-making process. And you can take whatever time you need to think about, discuss any information, all information that the defense puts forward. That's the law. We know you will do that. If you find that the aggravating factors in this case do not outweigh the mitigating, okay, it's up to you to analyze everything. If you find the aggravating factor here does not outweigh that information, mitigating information, then you must go on and decide on the other three sentences that the judge indicated were available to you. Right? You go on, if you find that the aggravating factors don't outweigh the mitigating, to look at 25 years to life, meaning life in prison, with parole eligibility after 25 years, or 30 years to life, which means, again, a life sentence, but with parole eligibility after 30 years, or life without parole. And that would be simply what it is, what I'm saying here. You spend the rest of your life in prison with no eligibility for parole. Those would be the options available to you if you find the aggravating factors do not outweigh mitigating information. decision. The law in the state of Ohio, we are sworn to follow, you to the notes to follow, and that law does provide for the death penalty in certain cases. The state of Ohio believes that this is one of those cases. We ask that you listen to that mitigating evidence, and when you're weighing that, and the aggravating factors, they're there and they worse than the crime. Okay? The death of Justin Winebrenner, the aggravated murder of Justin Winebrenner, occurred in the course of conduct where the defendant attempted to kill 2 or more people. We believe that that aggravating factor, the significance of that, outweighs any mitigating information that you're going to hear. And it worsens the death of Justin Winebrenner. That's what aggravating factor it is. So, we're going to go ahead and put some information into the record for you, some exhibits, and then we're going to sit down, and the defense is going to put out information for you, witnesses, to give you information that they feel mitigates the sentence, meaning they feel they want to give to you to show you that a death sentence is not appropriate. We trust that you follow the law as you have thus far, and we appreciate your devotion to the case all the way through. We know it's a hard decision that no one wants to make, but we understand that and feel that you can do that. So when we come back up here, probably tomorrow, and argue again, we're going to argue that the aggravating factor in this case does outweigh mitigation. And we're going to ask at that time that you impose the appropriate sentence in this case, which is the death penalty.
Thank you. Mr. O'Brien?
Thank you, Your Honor. Can I have a moment? Ladies and gentlemen, your job so far has been hard, and it's not going to get any easier. You are going to have to decide the punishment. The sentencing phase, mitigation phase, this is really the punishment phase. The trial phase is sometimes talked about as whether it's the guilt phase or not. So, what's going to happen for the next couple of hours today and tomorrow morning, I'm going to give you a little general idea of how the schedule is going to go. You folks are going to be asked to listen to about 12 people today. These people are going to be friends and family of Kenan Ivery. Tomorrow morning, you're going to be asked to listen to a psychologist, a representative of the parole board, and you're going to be asked to listen to Kenan Ivery. There will be some closing argument then tomorrow, late tomorrow morning is my guess, and then sometime around midday, your deliberations will begin. Now, you folks found Kenan Ivery guilty of aggravated murder with a death penalty specification. Mr. Griffin and I are not going to argue about that. That's done. You did your job as you saw it. Mr. Griffin and I and Kenan Ivery were disappointed. But we're not going to dwell on it, we're going to dwell on the future. And that future belongs today, begins today. This whole issue that you folks are going to be asked to consider is whether or not Kenan Ivery lives or dies. That's the issue. Now, some of you got very emotional when the jury verdict was read. We noticed that. You probably noticed also that Mr. Griffin and I and Kenan Ivery were not very emotional. We discussed that ahead of time. We were going to steel ourselves for whatever was said, good or bad, and not show any emotion. But if any of you thought that lack of emotion shows some sort of contempt or some sort of lack of remorse, that is misconception. You folks would have been very much off base. Our hearts are pounding in our chests. We can't eat, we can't sleep. It is a life or death decision. Now, tomorrow morning, the parole board representative is going to discuss with you exactly what a death penalty means in this state and what the 3 life sentences mean. And that lady, Ms. Kolach, is going to tell you that life means life. It's not what you've seen on TV, none of this Law and Order stuff, none of Hollywood. This is the real life in Ohio. And she's going to describe to you that life in prison means without parole, means someone dies in prison. Whether it's 10 years from now, 20 years from now, 40 years from now. Now, punishment is what you folks are going to decide. And what we're going to show you today, right now, is this example of, you've heard these phrases, aggravating circumstance, mitigating factors, and probably you folks have never heard those before coming out today. So what we proposed and prepared for you is a chart. This is the law in Ohio. This isn't my idea, it's not the state's idea that's there. This is what the legislature enacted down in Columbus. The law in this state says that, and in our case, we have one aggravating circumstance. And Ms. Shrooky just told you what it was. And in the law in this state says that that aggravating circumstance outweighs the mitigating factors that Mr. Griffin and I are going to show you for the next day and a half. Then your job, and the law says, you must vote for the death penalty. On the other hand, if during your deliberations you believe that the aggravating factor equals, or the mitigating factors equal the aggravating circumstance, then you must, this is the law in Ohio, decide one of the 3 life sentences. At the bottom, if you decide that the aggravating circumstances do not outweigh the mitigating factors, then once again, you have to consider one of the 3 life sentences. The people you're going to hear from are going to be people that know Kenan Ivery, have known him sometimes for 5 or 10 years, sometimes for his entire life. And they're going to ask you to spare his life. And when you get in that jury room, you're going to have some jury instructions. Not the ones that the judge just read to you, but there'll be jury instructions in there saying basically what I just showed you on that graph. But there's something else that I want you to concentrate on. And that's the idea that one of you could say, I don't believe that aggravating circumstances outweigh anything. I'm going to vote for one of the life sentences. One of them. You don't have to unanimously reject the death penalty. If one of you believes that that's not right, or 2 of you, 3 of you, you can then go on and decide whether or not which of the 3 life sentences is appropriate. One of you has that power to find a life sentence. And on behalf of Mr. Griffin and I, Kenan Ivery, ask for one of those life sentences. Thank you.
Okay, I'm going to ask you to, can you take that down? Thanks. All right then, on behalf of the state of Ohio, Mr. Baumel, do you have some evidence to offer?
Now, at this time, we are admitting all the testimony from the trial phase pertains specifically to the specification that we used to prove the specification that the defendant did purposely kill or attempt to kill 2 or more people. And that would include the testimony of individuals at the bar, police officers involved in the investigation, experts, be they from BCI or from the medical examiner's office. We would admit all that specific testimony for the jury to consider during its deliberations. We are also admitting for purposes of the aggravating circumstance and for purposes of the jury to have during their deliberations specific exhibits, and those would be the two discs of the security footage, being State's Exhibit 4 and State's Exhibit 105. State's Exhibit 167 being a timeline of the moments seen in those videos. We are also admitting specific video stills, Exhibits 153, Exhibits 160, and Exhibits 163, specifically showing stills that were testified to be at or almost near the time that the 4 shots were fired in this case. We are seeking to admit evidence that pertains to Justin Winebrenner's death in this case, photographs of his clothing, State's Exhibits 177, 178, 179, 180, 181, and 182, and those are the 3 different layers of clothing that Justin Winebrenner had on his body, which shows specifically where the gunshots went into the clothing as it pertains to his body. We are also seeking to admit State's Exhibit 171, which is a photograph of Justin Winebrenner at the medical examiner's office, showing the upper portion of his body and the wounds that he suffered. We are seeking to admit State's Exhibits 123 and 124, and these are photographs of the Ohio State jacket worn by David Eisel, once again showing, as the jury will recall, some of the defects in his jacket that are consistent with the bullet having gone through him. We are also admitting State's Exhibit 142, which is a still photo of the parking lot outside of Papa Don's, showing the defendant exiting his vehicle at that time. We are admitting State's Exhibit 144, which is the report of autopsy testified to by Dr. Dean in this case. And then finally, we are admitting State's Exhibits 59, State's Exhibits 80, and State's Exhibits 88, which are the 3 slugs, the fired bullets that were recovered in this case, 2 having been testified as going through the body of Justin Winebrenner, and then the 3rd being found inside on the floor of the Papa Don's bar.
Sorry, I'm just checking. What's that manila envelope?
This is just what was, the court reported brought all those items in that envelope. Based upon that, the testimony, the exhibits being admitted for the jury to consider during this portion of these proceedings, the state has no additional evidence.
All right. And the defense has already noted its objections. We've discussed those, and the court is going to be admitting these exhibits as proffered by the state.
We would remove our objection.
All right. Thank you. So those are the exhibits offered by the state, along with the testimony that Mr. Baumel described. And so with that evidence being admitted, does the state then rest?
That's correct, Your Honor. We would rest.
All right, then. We're going to hear from the defense. You may call your first witness.